Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Suppose you were arrested during an implementation of a search warrant which led to the alleged recovery of illegal drugs. You question the basis for the issuance of the search warrant, but the judge refused to release the records of the case. You go all the way to the Supreme Court. Can you compel the judge to show you the basis for the issuance of a search warrant? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 10th of January 2025, and in this two-part episode, we discuss search warrants in the context of two cases decided by the Supreme Court's Second Division. First is the case of Rafael Zafe III and Cheryl Zafe versus People, GR number 226993, May 3, 2021. And for our next episode, we will talk about the case of People versus Lucky Enriquez, GR number 264473, August 7, 2024. Both decisions were penned by Senior Associate Justice Marvic MVF Leonen. And because we are introducing changes to our podcast, we now have with us PhilJA lecturers and experts who can talk about the cases. And joining us to talk about the case is Chairperson of the Philippine Judicial Academy, Department of Humanitarian Law and Human Rights, and former Supreme Court Public Information Office Chief, Attorney Ted Te. Hi, Professor Te. Welcome to the Supreme Court Podcast. Happy New Year.
Happy New Year, Mike. Thank
All
you.
right.
Thank you for your invitation.
And thank you for joining us. Let's talk about this case of Zafe versus People. This is an illegal drug case involving the enforcement of a search warrant. So in the process of the enforcement, he was arrested, but he is questioning the issuance of the search warrant because supposedly there were no records that the judge could show. But let's talk about the search warrant first, just for the benefit of our listeners who might not be familiar with the processes. When we talk about search warrant, what do we mean, and how is that different from arrest warrants?
Okay, a search warrant is an order from a trial court, which is required before a law enforcement officer can enter into any premises, whether it be a house, a building, and it is constitutionally guaranteed under the Bill of Rights, Article 3, particularly Section 2. And in that particular article, the Constitution requires that the warrant must be issued by a judge after a personal examination of any witnesses that the applicant, which would be from law enforcement, would present to the judge. And the judge must determine in his or her personal examination probable cause in order to issue the search warrant. And probable cause would pertain to facts and circumstances that would lead a reasonably prudent person, not necessarily a lawyer, not necessarily a judge, not necessarily someone who understands the law, but a reasonably prudent person, meaning an ordinary person, to make a finding to conclude that the objects to be seized, as mentioned in the warrant, or the place to be are in the place to be searched, as also indicated in the warrant. So it's important that the warrant must contain, as required by the Constitution, a particular description of the objects to be seized and a specific description of the location. And so those are the requirements under the Constitution as already interpreted by the court in many, many cases involving search warrant applications.
And there may be some people who might have the misconception, Professor Te, that when you issue a search warrant, you can immediately arrest people in the premises found in the search warrant. Unpack for us first, when is it possible for law enforcers to be able to arrest people found in the premises of search warrants? Because we want to disabuse the minds of people that
Yeah.
when you talk about warrants, you can necessarily arrest a person.
There is a fundamental difference between a search warrant and an arrest warrant. A search warrant, as mentioned earlier, really pertains only to the seizure of objects or the search of a particular place. An arrest warrant only is issued if there already is a criminal case that is filed before the court.
Mhm.
And therefore, while an arrest warrant is also an order issued by a judge, it comes at the tail end of a process, the process which is known as preliminary investigation of determining if there is sufficient basis to charge a person for a
Mhm.
particular offense. The search warrant application comes at the start of the process because it usually is an attempt to locate objects that
Mhm.
can be used as evidence in the filing of a case. Now, to answer the question directly, can you arrest someone based on a search warrant? The categorical answer there is no. The search
Mhm.
warrant cannot be used to arrest a person, only a warrant of arrest. So, in the search of a particular premises, for example, if the court authorizes the search of a particular premises to look for specific items, the person's name cannot be included in the items to be seized. No?
Mhm.
Just to push it to its absurdity. You cannot seize a person by virtue of a search warrant. You can only seize or arrest a person by virtue of an arrest warrant. Now,
Mhm.
of course, there are recognized exceptions, to the warrant requirement to arrest a person under the rules of court and based on case law as interpreted by the Supreme Court. And
Mhm.
these are only three instances under Rule 113, of the rules of
Mhm.
court. And the first would refer to those cases which would fall under the general heading of in flagrante delicto, meaning caught in the act. So
Mhm.
this would pertain to a situation where the person who is to be arrested has just committed, is committing, is about to commit a crime in
Mhm.
the presence of the person making the arrest. And that is the important point to stress. It must be done in the presence. The second instance is when the person to be arrested has just committed an offense, even though it is not in the presence of the arresting person, and that arresting person has personal knowledge of facts to indicate probable cause. So this
Mhm.
is what we call the general category there would be hot pursuit.
Mhm.
And then the third is the situation where the person to be arrested is a fugitive or has
Mhm.
escaped from a prison. In those three instances, in flagrante delicto, hot pursuit, detained, escaped detainee, or fugitive from justice, the arresting person does not need a warrant of arrest because of the what we would call the exigency of the circumstances, because the person's already there. In order to apply for a search warrant, you would need to file the case, right? And so in those three instances, these are exceptions, no? But in the event that a search warrant is implemented in a particular premises, a house, a building, the search warrant cannot be authority to arrest the person. But
Mhm.
should the person during the search commit a crime in the presence of the arresting officer, then that arresting officer, under the exception, can arrest that person without a warrant.
Mhm.
Only in those three instances, should any of those three instances happen during a search warrant. But the arresting person cannot give the search warrant as an authority to detain or to arrest the person because it is not authority to arrest anyone.
Mhm. Right. In the context of the Zafi case,
Mm.
the allegations of the prosecution is that law enforcers were able to recover the alleged illegal drugs that were seized from the site. And so, therefore, that was the basis for the arrest. So, this case, the Zafi case, involves illegal drugs. But what other situations would require the application for the issuance of a search warrant?
Well, the things that you can seize by virtue of a search warrant on the fruits of a crime, the the means to commit a crime, no, and the proceeds of a crime. So, in this case, illegal drugs, no.
Mhm.
So that's both the means as well as the fruits of the crime.
Mhm.
No? But for example, if the crime that is alleged in the application for search warrant is the killing of a person, whether
Mhm.
it is murder or homicide, then the means to commit the crime, no? So it
Mhm.
could be a firearm, it could be a knife, it could be whatever that is alleged to have been used, no?
Mhm.
In offenses involving, for example, money or property,
Mhm.
that have, let's say, robbery or theft, no, the actual object that is the fruit of the offense, or if it is alleged that the object has been sold, no, the proceeds, the money that has
Mhm.
been derived from the sale. So those are things that can be alleged in the application. So that means that there must be a relation between the
Mhm.
objects to be seized as applied for and the offense that is stated in the
Mhm.
search warrant application. If there is no connection between the objects to be seized and the offense, then most likely the judge will say, there's no probable cause to issue the search warrant. Why are you seizing these objects when it bears no connection, it bears no relation to the offense? In many cases, the Supreme Court has already ruled that warrants like those would tend to be called general warrants, and
Mhm.
has described those warrants as fishing expeditions. No,
Right.
the one of the most famous cases that every law student reads in search and seizure cases is Stonehill versus Diokno, where
Mhm.
the Supreme Court quashed search warrants which were described as very general simply
Mhm.
because they referred only to journals, books of account,
Mhm.
without connecting what these journals and books of account had to the offense that was alleged
Mhm.
in the search warrant application. So I think that's the link that needs to be established in the application. What would be the connection of the objects to be seized, the things to be seized, and
Mhm.
the crime or the felony that is alleged in the search warrant?
Mhm. Only law enforcers can apply for a search warrant, for example. You cannot have a civilian or a ordinary citizen go to court and say, I'm going to search a property of this neighbor. So it
Yes,
has to go through law enforcers.
only law enforcement. Of course, a civilian can be the
Mhm.
witness, can be the
Mhm.
complainant, as it were. If the civilian has knowledge, no, personal knowledge of the facts to indicate probable cause, that person can be presented by the law enforcer. But the application is done by law enforcement to the court.
Mhm.
And
Mhm.
unlike a warrant, uh, a warrantless arrest, for example, under Rule 113, it is not limited to law enforcement. But
Mhm.
for a warrant of arrest, that must be served only by law enforcement.
Right.
It
Mhm.
cannot be served by an ordinary person, a non-law enforcement officer. But for warrantless arrest under Rule 113, actually any person
Mhm.
can effect that arrest.
Right. How crucial is it, Professor Ted, that in the application for a search warrant, you should have been able, if you were the law enforcer, you should have been able to present the witness to the judge and for the judge to have personally examined the witness. There is a requirement of personal examination under the Constitution. And this is the key issue in the Zafe case.
Yes.
Did the judge personally examine, or did she make a personal examination of probable cause for issuance of the search warrant? How crucial is that?
It's absolutely crucial. It's indispensable because the Constitution, Section 2, Article 3, requires, as you said, the personal examination of the complainant and the witnesses that may be presented. And the
Mhm.
personal examination, as again interpreted by the court in many cases, is not simply a cursory or routine examination. The
Mhm.
questions that must be asked by the judge are described by the court as searching questions,
Mhm.
meaning the court cannot just simply rely on records or documents submitted by the applicant and determine probable cause simply by looking at the records. The judge must herself or himself personally be satisfied after asking the so-called searching questions that the
Mhm.
court requires. And in the Zafi case, for example, the court described the necessity of having a factual basis to support a judicial determination of probable cause. And the
Mhm.
court said that this was a crucial requirement. Without that factual basis, then probable cause determination would be suspect. And in fact, the subject of the search warrant, in this case the Zafes, could actually question whether or not the judge really had the basis to make a determination of probable cause.
Mhm. Is it necessary, Professor, that there should be a transcript or a deposition made by the complainant in the presence of the judge for the issuance of the search warrant to be upheld.
Yes, again, all courts are courts of record.
Mhm,
And there is no justification for saying that the application for a search warrant, which is done actually unilaterally,
mhm,
because of course, the subject of the search warrant application, the target, is not brought in. So it is already unilateral, and it
right.
is often ex parte. It is not often, it is always ex parte, meaning
Mhm,
only one side is there, the applicant and his or her witnesses. And therefore, the court which examines, the judge which examines the applicant and any witnesses or documents that may be presented, must have a record of whatever is established by the personal examination. That that record must be present, meaning it cannot be done off the record. The
mhm,
judge cannot say, for example, okay, I've already talked to the applicant, and we talked while we were coming over here, and I'm satisfied that there is probable cause. There
mhm,
has to be a record, and that record must be accessible. And I think that is one of the issues that the court resolved in Zafe, because that is
mhm,
precisely what the Zafes were asking for, because
right.
they were arguing that there was no such examination, and if there was such an examination, then they wanted access to the records. What about the examination would have led the judge to make the probable cause determination? And
Mhm,
and so the court in Jaffe did say that there must be a record of the facts that were considered in determining probable cause. It cannot just be issued. The warrant cannot just be issued based on a certification that
mhm,
that I've examined the person already. There must be a record that establishes that, and that record must be accessible. It should be included in the right of the subject of the search warrant to examine the factual basis in determining probable cause. And
mhm,
again, this was the ruling of the court in Zafe, that the subject of the search warrant, in this case the Zafes, should be given access because it's part and parcel, it's integral to their right to due process, because they cannot exercise their remedy to challenge an unreasonable search and seizure if they cannot get access to whatever record there was of the personal examination. And so that in the case of the Zafes, the court sustained and affirmed the invocation of the right of the Zafes to that record and to examine that record if it
mhm.
existed.
Right. And what about the claim of the judge here? He was claiming presumption of regularity
Mm.
in the performance of judicial functions. Wouldn't that be sufficient justification for refusing to furnish copies of the basis for issuance of the search warrant? Talk to us about the interplay between presumption of regularity and the rights of the accused.
Yeah, it's notable that uh, the presumption of regularity of official functions is not in the Constitution.
Mhm,
It is in the rules of court, and it is established in jurisprudence. So it is judge made essentially.
mhm,
And the right to be presumed innocent, the right against unreasonable searches and seizures, are both in the Constitution. They're in Article 3. They're in the Bill of Rights. And so in the hierarchy of rights, which the court has actually established already in many, many cases, the presumption of regularity of functions cannot override a constitutional right. The invocation in this case of the Zafes, that they were invoking the right to be protected against the unreasonable searches, the search and seizure that was inflicted on them, that cannot be overridden by the judge's invocation of the regularity of functions. No?
mhm,
It cannot simply be done because the constitutional guarantee of protection will then be rendered meaningless
mhm,
if all that the of if all that law enforcement or the state agents would do is to invoke regularity. Then
mhm,
the constitutional guarantees would be meaningless. So again, in this case, the court sustained the effectivity of the constitutional guarantee, in this case, Section 2, the right against unreasonable searches and seizures over in effect, a disputable presumption that the official functions have been performed with regularity, which now would fall to the judge or to the state to justify
Mhm.
if indeed there was official function that was performed. But the effect of the invoking the protection of Section 2 would effectively override, that disputable presumption.
The judge here also invoked the state's inherent police power in justifying the examination of the search warrant supporting documents, refusing to reveal them to the accused. Will that not be considered a justification?
The court did not agree with that invocation. Again, in the first place, I think the judge's invocation of police power was misplaced because
Mhm.
police power is a legislative power, and it is usually expressed by law. And
Mhm.
therefore, a specific law, for example, that would remove specific privileges could be attributed to a lawful exercise of police power. But in this case, what the judge was simply invoking was the supposed concern of the state, to promote the public welfare by regulating or even restraining the use of liberty and property, in order to promote the public interest. So
Mhm.
that's really not effectively, that's really not police power, no. But
Right.
the court disagreed with that, and the court again stressed, that when we talk about restrictions, limitations on fundamental rights, particularly those under Article 3 of the Constitution, such as the right against unreasonable searches and seizures, the court said that the standard that must be used by the court is strict scrutiny, right?
Mhm.
And therefore, when the court looks at strict scrutiny, what must be shown is that there is a compelling state interest that is
Mhm.
sought to be upheld by the act that is questioned, and that the means employed by the state here are the least restrictive, least disruptive. In the words of the court, this would have to be narrowly tailored, meaning
Mhm.
it should not be overbroad, it should not be sweeping, it should not be ambiguous, right? And so the court said that even were we to indulge, right, that argument, there was no showing that denying the Zafes access to the records of the search warrant application would actually, be meeting a compelling state interest, and that it would be the least restrictive of the means to
Mhm.
limit the petitioner's right. So the court said it was error for the judge to deny petitioners access to the records, because then that would actually render meaningless again the petitioner's fundamental rights.
Mhm.
Effectively, the court was saying, uh, what the judge should have done was the reverse, meaning should have granted access, because that actually would have ensured a compelling state interest, because the compelling state interest in this case would have been to uphold the
Mhm.
constitutional rights of the Zafes.
I'm curious about the conclusion of this case because how did it go from questioning the refusal to release records of examination of witnesses or documents to actually dismissal of the case?
Hmm.
Because we were still in the preliminary portion of the case, even though it lasted 5 years. But essentially, we're still at the start of the trial. They were still questioning why the search warrants were issued. There was no trial yet. And yet, the Supreme Court decided to dismiss the case altogether. What was the key factor here
Yeah.
that the court relied on for dismissing the case?
The principle that the court invoked here is a principle that they've invoked before, which is the effect of a manifest deprivation of constitutional rights, particularly the right to due process. That's the
Mhm.
first. And the second is the delay in the resolution of their cases, independent of the action of the petitioners. No? So, uh, based on those two grounds, the court said that the dismissal of the criminal charges were merited, because, as the court had already explained in the decision, the deprivation of access to the court records was an impairment of the right to due process on the
Mhm.
part of the Zafes, and that it had taken 5 years, no, already,
Mhm.
was also an indication that the right to a speedy trial had already been violated. In fact, the court noted that more than 5 years had lapsed from
Mhm.
the time that the charges, the informations were filed against the petitioners, and that there was no resolution on a very fundamental matter. In fact, a threshold issue, such as the right to be furnished the records of the search warrant application. And therefore, the court said, consistent with the right to speedy trial, there was adequate basis to dismiss the charges against the petitioner. The court
Mhm.
also noted that the search warrant itself, on its face, no, was defective because it was not as specific as required by the Constitution. The court
Yes, exactly.
noted that the the description of the place was insufficient. It simply mentioned a residence
Mhm.
located in a barangay which is being used as a den, no? And therefore, with such a description, it would leave the implementation of the search warrant
Mhm.
open to guesswork on the part of law enforcement. And the
Mhm.
rationale for not allowing a search warrant to be ambiguous is precisely to limit the speculation or guesswork on the part of the officers. The requirement of specificity actually would simply tell the law enforcement officers, this is the only place you can go to. These are the only things you need to get. No other thing should be seized. No other place should be subject of your search. And
Mhm.
the court noted that this was not the case in this particular search warrant, and therefore it said it left the scope of the search, no, subject to the discretion of the implementing officers. And so I don't know how large that barangay is, no,
Right.
but it simply said a residence located in the barangay, which is
Mhm.
being used as a den.
Mhm.
Even if it is true, if there was more than one residence being used as a den, then definitely there was already a violation of the requirement under the Constitution. So, under those two considerations, no, the
Mhm.
violation of the rights under Section 2, and then the violation of the right to speedy trial, as the court had already mentioned in previous cases, the court said it merited a dismissal. So outright,
Mhm.
even without benefit of a trial, the court already dismissed the case, no, and voided the search warrant, declared as inadmissible anything that was obtained by virtue of the search warrant, no, and then dismissed the case because of the manifest violation of the rights of the petitioners who were the accused here, the Zafes.
All right. Professor Te, we will have to pause our discussion on search warrants for now. For our listeners, do join us next time for a continuation of our discussion where we talk about the limitations and the proper implementation of search warrants, as alluded to by Professor Te already. Also, we will have again Professor Te in the next episode. So for now, Professor Te, thank you for joining us.
Thank you, Mike.
Right. And if you wish to read the full text of the decision we discussed today, you can go to the Supreme Court website at e-library and search for Rafael Zafe III and Cheryl Zafe versus People, GR number 226993, May 3, 2021. Here's Steph Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week. The Supreme Court reiterated that a certificate of registration from the Department of Labor and Employment, or DOLE, does not automatically mean a manpower agency is engaged in lawful job contracting. In a decision written by Associate Justice Jopar B. de Maampao, the SC's Third Division held that Nozomi Fortune Services, Inc., a manpower agency, engaged in labor-only contracting when it hired Celestino A. Naredo and assigned him to Samsung Electronic Mechanics Phils as a production operator. The court said determining whether a manpower agency is engaged in legitimate job contracting or labor only contracting requires looking at all the facts and circumstances. A DOLE certificate of registration may help prevent assumptions of labor-only contracting, but it does not serve as conclusive proof of legality. The Supreme Court upheld Sections 6 and 29 of Republic Act No. 9136, or the Electric Power Industry Reform Act, or EPIRA, stating that electricity generation and supply are not public utility operations, but are still subject to the regulation of the Energy Regulatory Commission, or ERC. The court ruled that to be considered a public utility, a business must provide a service essential to the general public. Power generation and supply companies offer their services to limited customers and do not deal directly with the general public. However, they remain under government regulation because the EPIRA expressly provides safeguards against abuse or irregular activity. The Court en banc also upheld Section 34 and Section 24, Paragraph B, Subparagraph 2 of the law empowering the ERC to fix and approve the universal charge imposed on electricity end users, and Section 43, Paragraph F, which gives the ERC the power to fix charges to allow distribution utilities to recover their losses. The case stemmed from a petition challenging the constitutionality of certain EPIRA provisions. The ERC earlier authorized Manila Electric Company, or Meralco, to recover its generation costs from consumers on a staggered basis. The Supreme Court has approved the rule on family mediation in a resolution dated November 5, 2024 in AM number 24-02-06-SC. This initiative aims to address the emerging need for family mediation, both domestic and international, enhance the efficiency of family courts, reduce court backlogs, and promote the best interests of the child. The rule also introduces innovations in dealing with family cases. Family mediation involves a mediator, acting as an impartial third party who facilitates the resolution of family disputes and helps the parties in reaching voluntary agreements. The rule took effect 15 calendar days after its publication. It was published in a newspaper of general circulation on December 14, 2024. The Supreme Court reiterated that disciplining children, even if it results in physical injuries, does not automatically amount to child abuse. To be considered abuse, there must be clear intent to harm a child's dignity. In a decision penned by Associate Justice Josep Y. Lopez, the SC's Second Division upheld the conviction of a father for child abuse after subjecting his 12-year-old daughter and 10-year-old son to violent and excessive discipline. He was found guilty of violating Republic Act No. 7610, or the Special Protection of Children Against Abuse, Exploitation, and Discrimination Act. The SC emphasized that while parents have the right to discipline their children, such measures must not be violent, excessive, or disproportionate to their misbehavior. But without the clear intent to harm the child's dignity, the offender cannot be held liable for child abuse but can be charged with other crimes under the revised Penal Code. The Supreme Court has partnered with the Korea International Cooperation Agency, or COICA, Philippines, in conducting a preliminary survey aimed at modernizing court systems in the country. This partnership will create an electronic verification and case and evidence management system, digitize court records, and train court personnel. The project seeks to reduce case backlogs and streamline adjudication processes by leveraging cutting-edge technology. COICA, a Korean governmental organization for official developmental assistance, will lead efforts to introduce advanced systems inspired by the Republic of Korea's modern judicial practices. Applications for the 2025 bar examinations has commenced starting 8 o'clock in the morning of January 8, 2025, and will run until 3 in the afternoon on March 17, 2025, based on the announcement from the Office of the 2025 Bar Examinations Chairperson, Supreme Court Associate Justice Amy C. Lazaro Javier. For bar bulletins and other information about this year's bar exams, you may visit the Bar 2025 microsite at the Supreme Court website, sc.judiciary.gov.ph. In line with its efforts to streamline court processes and decentralize some functions of the Office of the Court Administrator, the Supreme Court held information drives for the Office of the Regional Court Manager, or ORCM, in Judicial Region 9 in Zamboanga City on January 6, led by Associate Justice Antonio Tico Jr., Judicial Region 10 in Iligan City on January 8, led by Associate Justice Chaparbi de Maampao, and Judicial Region 5 in Legazpi City on January 10, led by Chief Justice Alexander G. Gismundo. The court also held a user training workshop for eCourt PH version 2 at the Judicial Academy Philippines in Tagaytay City on January 8 to 9, and a dialogue in San Fernando City, La Union on January 10. Lastly, the Supreme Court launched the Regional Mental Health Unit at the Office of the Regional Court Manager for Judicial Region 1 in La Union on January 10. And that's your Supreme Court this week. I am Tiffany Dobletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rempilio, and May Sibal as researchers, Don Ryan Balza and Victor Laranio as sound editors, and Tyke Flores and Jerome Obatumalake as web editors.